Welcome to EUPrivacyForAll Session47 on GDPR, Article 58, Powers of the Supervisory Authority. The final numbering of the article regarding the powers of supervisory authorities is Article 58. It announces that each supervisory authority shall have investigative powers, that is to say, the powers to order the controller and the processor to provide any information required, to carry out data protection audits, to carry out a review on certifications, to notify the controller or processor of an alleged infringement, to obtain access to all personal data or access to any premises. It also has corrective powers, that is to say, the power to issue warnings, to issue reports, to order to comply with the data subject's requests, to order to bring processing operations into compliance with the GDPR, to order to communicate a personal data breach to the data subject, impose a temporary or definitive limitation, including a ban on processing, to order the rectification or erasure of personal data or restriction of processing, to withdraw a certification, to impose an administrative fine, to order the suspension of data flows. Finally, each supervisory authority will have authorization and advisory powers, that is to say, the powers to advise the controller or to issue opinions on the national parliament, to authorize processing operations, to issue an opinion and approve draft codes of conduct, to accredit certification bodies, to issue certifications, to adopt standard data protection clauses, to authorize contractual clauses, that is to say, ad hoc clauses, to authorize administrative arrangements, and to approve binding corporate rules. The exercise of those powers, pursuant to this article, shall be subject to appropriate safeguards, that is to say, effective judicial remedy and due processing, according to what is laid down in the Charter. Each member state will have the possibility to provide by law that its supervisory authority have powers to bring infringements of this regulation to the attention of the judicial authorities. Each member state may also provide by law that its supervisory authority shall have additional powers. A key recital in the GDPR is recital 129. It sets forth that the supervisory authorities should have in each member state the same tasks and effective powers, notably regarding investigation, corrective powers and sanctions, and authorization and advisory powers, in particular regarding complaints from natural persons. Such powers should include the power to impose a temporary or definitive limitation, including a ban on processing. It also stresses that the measures taken by the supervisory authority concerned should be appropriate, necessary, and proportionate. That is to say, taking into account the right of every person to be heard before any individual measure would be taken and affect him or her, in order to avoid superfluous costs and excessive inconveniences for the persons concerned, meaning data subjects, of course, but also controllers and processors. Each legally binding measure should be in writing, be clear and unambiguous, and it may give rise to judicial review. It is also referred to in Article 56.3 the fact that a supervisory authority may confer powers, including investigative ones, on a seconding supervisory authorities or staff involved in joint operations. Article 79.3b also reminds us that without prejudice to the corrective powers of one supervisory authority, each member state may lay down the rules on whether and to what extent administrative fines may be imposed on public authorities. Currently, Article 28 of the Directive already identified those three buckets of powers, that is to say, investigative one, access and collection of all information necessary, intervention ones, that is to say, delivering opinions regarding operations, ordering the blocking, erasure, or destruction of data, imposing a temporary or definitive ban on processing, warning, admonishing, and referring the matter to national parliaments. And finally, the power to engage in legal proceedings or to bring violations to the attention of the judicial authorities. As much as in GDPR, the decisions of the supervisory authority which give rise to complaints may be appealed against through the courts. What should accountable data controllers and processors get prepared for? First, being aware of their obligation, anticipating the powers of national supervisory authority regarding the information to be provided, data protection audits, review on certifications, the obligation to notify any alleged infringement, to obtain access to personal data or access to premises, to issue warnings or reprimands, to comply with data subjects' requests on supervisory authorities' requests, to bring some processing into compliance, to communicate a personal data breach to the data subject, to impose a temporary or definitive limitation, including a ban on processing, rectification, restriction, erasure of data, but also the fact that a DPA could withdraw certification, impose administrative fines, and have a whole set of advisory powers. Controllers and processors should also bear in mind that supervisory authority powers are subject to appropriate safeguards, that is to say, effective judicial remedy, but also, on the contrary, that they have the power to bring infringements to the attention of the judicial authorities. Each member state may provide additionally into the law that the supervisory authority shall have additional powers. Today, the consistent implementation with regard to investigation and certification may trigger some questions. It will be clarified by EDPB and upcoming practices by national supervisory authorities.